We'll go on the record in People versus Michael Woodworth. This is file number 256797, 6798, and 6799. The record should reflect Mr. Woodworth's present here in the courtroom today. Counsel, put your appearances on.
Good morning, Your Honor. For the record, my on behalf of the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Woodworth.
So this is the date and time set for sentencing hearing in this matter. Mr. Woodworth, did you have an adequate opportunity to go through the pre-sentence report and discuss that with your attorney?
Yes, Your Honor.
Okay. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rowland, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
None, thank you.
Any victims that wish to address the court today?
No, Judge.
Anything you would like to say on behalf of the people for allocution?
I do, Your Honor. There's a recommendation from probation from the Department of Probation and Parole for probation of 2 years, credit for 250 days already served, 12 months. With all due respect to the department, this is the defendant's 12th, 13th, and 14th felony. And while there's much made perhaps as a positive that he's now working, with all due respect to that, the people say, so what? It's a situation where he's got a job now, but that's because he's looking at now incarceration. I don't think in this particular case for an individual who has this many prior felonies, and I would point out to the court that under number 21 and 25 of his adult record, it indicates he got 9 months for committing the same type of felonies that he's before the court now for. I don't think he should get a light sentence. I think this is a circumstance Mr. Woodworth should be returned to the Department of Corrections, if for no other reason than the protection of society, because he's a career thief and everybody keeps having to pay for his mistakes. Now, I understand an argument is made that incarceration is expensive, but also what's the expense of continuing allowing criminals to complete the same criminal acts over and over again at the risk of society? People just don't see that makes much sense. Thank you, Your Honor.
Thank you, Mr. Church.
Thank you, Your Honor. The recommendation here makes sense through two lenses. Yes, there's history here. I think it is clear both from MDOC and the statutory provisions that have come out in recent years that we're shifting the way that we look at how sentencing should happen on nonviolent offenses. And the movement is away from sending people to MDOC for nonviolent offenses. These are nonviolent. And I think that's important. And that's probably a heavy driving factor behind why the recommendation is the way that it is. Even the resisting and obstructing, which arguably could be considered violent, if the court looks at the description of that offense, it's not violent. The police showed up. He basically ran out one door and was told to stop, and then stopped. I mean, he briefly had the idea that he was going to run away. They told him to stop, and he did so. It's not a violent offense. To Mr. Woodworth's credit, he's openly accepted responsibility for what happened. Never denied anything to me in terms of what occurred. He was disciplined in terms of what he hoped and wanted to get in terms of an offer. We were able to achieve that and ultimately result in our plea. He admitted what he did here. He explained the circumstances to me. It doesn't make it right, but he said, we were getting to the holidays. I was feeling the pressure that I think a lot of parents would feel at that time. And he felt pressured to be able to give his kids a holiday that he couldn't otherwise afford to do. Okay. I'm not saying that because it makes it right, because it doesn't. But I do think it helps the court to understand how we get to this situation. The circumstances here would not seem to me to warrant departing from the recommendation here and imposing an MDOC sanction. It would also indicate from the last offense, I think the PSI actually is attached here, or at least I think I received a copy of it. I think this is a progressive sentence from that, because from what I saw in the last one, it sounded like there was jail that was imposed but held in abeyance as opposed to being imposed up front. In this circumstance, he's been incarcerated basically well, basically the whole year, all of 2025 to this point. So he has a substantial amount of credit. I mean, essentially 9-month credit already in the file. So through that lens, I think it makes sense for the recommendation as it is. I think it makes sense to follow it. In addition to that, Mr. Woodworth has work available for him if he is able to be released. That employer is actually here today in the courtroom, indicated to me right before court today. I mean, he's ready to go and able to start working. The restitution has to get paid. The only way that's going to happen is if he gets out and gets working. So I would suggest to the court, I think the recommendation here is appropriate, given that it's nonviolent, given that it does continue to progress, be progressive punishment from what the last sentencing appears to have been, and given the circumstances surrounding this event. Thank you.
Thank you. Mr. Woodworth, is there anything you wanted to say today?
Yes, Your Honor. I know I messed up. I'm embarrassed. I'm humiliated by it. I should have done better. The last 3 years, I went through 3 losses. Lost my mom. That cost me almost $11,000. Messed me up. My mom's my everything. Then I lost my grandfather, Jack Fleming, then my stepmother. All in the matter of 3 years. Going through custody stuff with my kids. I fell in hard times. I made bad decisions. I'm not proud of it all. In the recommendation, I do feel I need counseling and stuff. I feel like probation could help me a lot. Getting the counseling and stuff I need. I know I need help with that stuff. And I'm just trying to get a chance to pay it back and do right and trying to turn my life around.
I did read through the report, so I'm familiar with the 3 circumstances that bring you before the court here today, the 2 retail frauds and then the R&O. I agree with Mr. Trush. This wasn't an assault of R&O, it was more of a fleeing type of situation. And certainly the retail frauds are non-assaultive type offenses. So I think if we looked at each one of those on their own and in a vacuum, outside of context, I think a local sanction probably would be appropriate. But these things didn't occur in a vacuum, and they did occur within a context, and that context is, your prior history and the way things have gone. You've got 16 prior jail sentences and 9 times prior on probation. And in my view, probation, the purpose of probation is when you have somebody who's demonstrated either because of their past history, other things that they've done, or by the circumstances of the crime, that there's potential for rehabilitation. And so it's worth investing some resources from the community to see if we can get that person back on the right track. After you've been on probation for 9 times, to me, probation is no longer a consideration. And we're not going to keep doing the same thing over and over again and hoping that this time it's going to make a difference. I think after 9 times, it's been pretty well demonstrated that whatever drives you to commit these crimes is something that's not going to be helped or corrected through probation. So I don't think that's appropriate in this case. And again, with your prior history, it shows, and a lot of your prior history is theft crimes. And it shows that when you fall on hard times or something's not going right, the direction that you go is to commit these types of offenses. And with your history, again, it doesn't give the court a lot of confidence that somehow this time is going to be different and things are going to change. And so with that kind of record, the court's primary focus at this point is preventing you from being able to commit crimes by taking you out of the community. And I think that's what's called for in this case, given your past history, given the nature of the crimes here and the circumstances. I think a Department of Corrections sanction is absolutely warranted. I think there are some mitigating factors that Mr. Trush mentioned that lead the court to a sentence that's in the middle of the guidelines as opposed to at the top end of the guidelines. So I am going to depart from the recommendation to the extent that the court is going to sentence you to the Department of Corrections sanction. So as to file number 6797, which is retail fraud in the first degree, the court is going to sentence you to 24 months. Correct. 24 months to 7 years, 6 months in the Michigan Department of Corrections. You do have credit for 250 days served. And that charge, a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to file number 6798, the court is going to sentence you to 24 months to 4 years in the Michigan Department of Corrections. On that file, there is a $130 crime victims assessment and a $68 state cost. As to file number 6799, which is retail fraud, 24 months to 7 years, 6 months. Again, with a $130 crime victims assessment and a $68 state cost. You have the ability to seek an appeal of these sentences. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. And Mr. Trush, if you can.
Judge, you're including restitution in that order?
Oh, I'm sorry, the restitution amounts. As to file number 6799. What is the restitution amount on that one, Mr. Rolla? Or are they lumped together?
I think they're lumped together. Yes, I remember correctly, Judge. I can give you individually as to each of them if you want.
I think we do need to make them individually since they're different file numbers.
Give me a moment.
Mr. Brunikel did not put those in there. In the
As to file. As to file 6797, the restitution amount is $1,102. So 1,102.66. That's owed to Meyer, MEIJER. As to as to file number 256799. Restitution, it is just a minor, that's right, never mind, I apologize, because the other property was recovered, so, okay, there's no restitution over to the other, so it is just to the one.
and Mr. Trush has Mr. Woodworth acknowledged receipt of his appellate rights.
Yeah, I'm sorry, to interrupt. I'm just trying to make sure we agree with the restitution number. I went over the advice of rights with Mr. Woodworth prior to court. Those have already been executed in the term of the court.
Okay. And for the record, all those sentences to be served concurrent to each other. Mr. Rolla, is there anything else that we need to address in this file? For these files.
Judge, we want to get the restitution correct. There's an issue that probation control just brought to me regarding recovered items, but I was looking at our files and it indicated. Right. It was one's asking that was recovered. There was the other ones that wasn't recovered. I'm gonna pull up this right here. I'm gonna look at it specifically. The report indicates some property was recovered, Judge, and that's
two of the funds.
Okay, which ones? So is it 220?
797, it's 250 days of credit,
Okay,
and the other two, it's 250.
okay, 251 on the other two. Okay, thank you.
Okay, here we go.
The PSI reflects that the only restitution is in file 6797 of the $1,102.
Correct, because it was recovered in the other file, and that's my understanding, Judge.
Okay, so are we good on that?
But, and what I mean, my reading of this file indicates that so that file comprises two instances. The 21st and the 28th.
Right.
They're indicating that the items on the 28th were all recovered. So, I mean, if that's correct, wouldn't the number be the 540?
The property that was recovered was the other file, and that was $732.04, which he was caught trying to leave with, but didn't get away with. That's according to Officer Collins' Waters report, page 4 of 6, case number 344210145.
So Mr. Trish, but I think you're right, because, so we're just dealing with file 6797. There's no question that 6799, there's no restitution.
Right.
So 6797, they recovered the items stolen on December 28th. So the only ones that weren't recovered were the ones that were taken on 12/21, and that's 562.42. That's what the PSI. So the court will order $562.42 in restitution payable to minors. Oh. All right, thank you. That's all for this. People versus Kenneth Krueger, case number 56832.
Right, John, my Carl Pap.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Krueger.
Should reflect Mr. Krueger's present here in the courtroom today. Mr. Krueger, can you tell me the status of this file?
Yes, Your Honor. So Mr. Krueger obviously has been released from his sentence in Sheboygan. We had an opportunity to sit down and discuss the matter. After that, I had an opportunity to discuss it with the prosecutor. The discussion with the prosecutor, we frankly kind of left it with, he indicated to me he would consider my proposal. So I would suggest to the court that I think there's two ways that we can kind of go on that, and I'm going to suggest my preference. I obviously we can ask for an adjournment. I think we're getting a little old at this case. However, again, I think where we've left the negotiations and having been able to go through things with Mr. Krueger in person was obviously significant. I think the court can probably recognize some of the difficulties of trying to communicate with them in jail. So my preference would be, I would ask the court to consider one more adjournment so we can kind of complete the negotiations there. The other option obviously would be if the court wanted the docket and set a final status conference. The reason I don't prefer that option is if we do wind up on a trial track, I think it's likely there's going to be a motion filed. And frankly, I don't kind of want to put that on Mr. Rolla's plate, my plate, and the court's plate, if we're not going to actually wind up needing it because, we wind up with a deal.
Okay. Mr. Rolla?
Trish's office to contact our office. I having to follow up on a few matters in regards to his request on behalf of his client. I have not, because of course this is circuit court motion weekend, been working on briefs, have not been able to fully follow up on that, but I have no objection to one more jury card on status.
Okay, so are you going to be able to get that information so that you can?
Probably within a week, Judge.
Okay.
It's just unfortunately, there's only so many hours in the day.
No, I understand. So we'll set this for a plea cutoff hearing in 30 days. So even if this does get set for trial, Mr. Trush, that's going to be a hard plea cutoff. This case was found over in April. So if we're going to have a plea, it needs to happen next month. If we don't have a plea, then I'm just going to consider it as a lock for going to trial. So, Mr. Krueger, it's important over the next 30 days that you stay in touch with Mr. Trush, that you talk to him about any plea offers that are made, and that at our next hearing, you're ready to make a final decision on whether you want to go to trial or enter into a plea agreement. Okay.
Yes, Your Honor.
Mr. Rolla, anything else that we need to address for the record today?
Not from the people, is anything.
Mr. Trush.
No further, thank you.
Mr. Krueger, do you have any questions?
No.
Okay. Thank you. That's all for today.
Thank you.
All right. And then I did have a question for counsel. We have Mr. Pap scheduled at 9:30 and then later this afternoon. Do we know when? I don't believe Department of Corrections has brought him here yet this morning. What was your understanding?
Well, there's two different files too.
Right.
I guess I don't have an answer to that because I didn't realize there were two different files.
Yeah. Okay. All right. So you were prepared to go forward at 9:30 and later this afternoon?
And unfortunately, I'm in front of Judge Hessling this afternoon.
Judge, with all deference to Mr. Trush, I believe it's a different counsel.
Oh, it is.
file.
That's right. Okay.
That's the state appellate defender's office.
Okay.
So Richard, you're off the hook.
All right.
My heart rate could slow down a little bit.
You handled it really well. You didn't look panicky.
Just pale.
You're good under pressure. I don't say that. Okay. All right. Were you anticipating Mr. Pap being here this morning for your motion?
I mean, given the nature of the case, I would prefer he see the motion.
Okay.
I mean, I don't think he's going to actually participate in it, but he has been active in the case.
And they may be connecting him right now, actually. So.
There was a red done, Judge, so I can confirm that part.
Let's see if this is Mr. Pap. Oh, that is, okay. Mr. Pap, are you able to hear me okay?
Yes, sir.
Okay. Are you ready to proceed, Mr. Trush? We're a little bit ahead of schedule, but you're ready to go.
Yes, Your Honor.
Okay. All right, we'll go on the record in People versus Carl Pap. This is file number 256857. The record should reflect that Mr. Pap is present today by Zoom video from Department of Corrections. If I could have counsel for appearances on.
For the record, Your Honor, I call back People.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Pap.
Mr. Trush, this is your motion to quash. I did have a chance to review your motion. And I understand, you know, your argument is that there wasn't sufficient evidence presented at the preliminary examination for a court to find that there's probable cause to believe that the alleged crime occurred in Otsego County. And so it's kind of a venue jurisdictional challenge to the court proceeding and the bind over. Is that a fair statement?
Yes, Your Honor, and having reviewed the prosecutor's response, I think largely we agree as to sort of the factual underpinnings of it. At the preliminary exam, there were two people who testified in essentially the extent of their testimony was that Mr. Pap lived in Otsego County at the time that this conception is believed to have happened. And I think that's about the extent of it. I mean, I think they tried to and wanted to get further than that, but there isn't. The alleged victim did testify. Ultimately, her testimony was stricken as, she asserted her Fifth Amendment right and then didn't, and then did, and we kind of got to an impasse where there was, I think, one question that she refused to answer or did not want to answer, and everything, all the testimony was stricken. Even in that, I mean, there's nothing to establish where the event took place if it did. Now, the two things I guess I want to point out to the court, in the prosecutor's responsive brief, he put the venue jury instruction in. And I think it's valuable and helpful. There is a special jury instruction for criminal sexual conduct cases, and it indicates they don't have to prove a time and they don't have to prove a date necessarily. But what's important is they do still have to prove a location. And again, in this case, other than that he lived in this county, there's not anything to establish that. And I mean, I say that because, I mean, to look at this in the context of any number of other cases, how many people from outside of the county come into the county and potentially commit crimes? I mean, I imagine if the court were to look at its docket today, at least half of the docket, I'm sure, is people who are committing crimes outside of their home county. So, I mean, fundamentally, I think there's an issue here. I don't think there's enough for a bind over. And I mean, certainly if the motion is denied here, I mean, this is going to be an issue for trial. That's for sure.
Well, and it certainly could be an issue for trial because there's a vastly different standard that would be applied at trial. But isn't there more than just Mr. Pap was living here at the time, though, right? I mean, we have the alleged victim had a child that I don't think there's a factual dispute that Mr. Pap is the father of that child. So we have more than him just living in the county. We have him living in the county at the time, and by backwards calculation, or forwards calculation, we have a child that he fathered that would have had to been conceived about the time that he was living in Otsego County. So isn't that an additional fact that we have here?
Hey, I mean, without conceding that, that may be a challenged issue at a trial, but accepting that for purposes of this hearing, I mean, even if we accept that he fathered a child and he was living in Otsego County, does not mean that act occurred within this county.
No, I agree with you, but that's a fact that if a jury were to believe those things could conclude or could find that the act that led to that child occurred in Otsego County based on the timing.
I don't know that I would agree. I mean, I guess I can't suppose what a jury would or wouldn't rely on.
No,
it certainly doesn't necessarily follow.
Okay. All right. Okay. Thank you. Mr. Rowland.
Yes, thank you, Judge. A couple of things first off.
Mr. Pap, did you need to talk to your lawyer?
Yeah, if I could give it 2 seconds.
Do you want to sign in so you can speak to Mr. Pap?
I can do that.
That's up to you.
Yeah,
You
Or
wanna-
my question,
Mr. Pap, is
Or
there
I
something
think
you need to
it's-
talk? Hold on, let me
there's
talk.
something I
Is it-
could say, There was testimony on top of that. I was just gonna let you know.
No. I definitely don't want you to say anything. Let me
Okay.
log in and we can talk in a breakout room. If it's something that we need to say, I will say it.
All right. Mr. Pap, I'm gonna put you into a breakout room with your lawyer, okay? So you can talk to him privately.
Yes, Your Honor.
This is the next report. I think we tried to get it to Jen yesterday, maybe.
Okay, Mr. Trush, I'm gonna put you into that breakout room right now.
Well,
Okay, Mr. Pap, I think Mr. True should be heading back in here.
yes, Your Honor.
Okay, we'll go back on the record in People versus Pap. Mr. True, did you have an opportunity to speak with Mr. Pap?
I did, and he had just reminded me and wanted me to remind the court. There was testimony at the preliminary exam about his work. There was testimony that, you know, his work took him basically all over the state. And there was testimony from, again, the alleged victim's testimony was stricken, but testimony from both her and from the mother, or I'm sorry, Britta, that the alleged victim would frequently travel with him all over the state. So again, I think that is important to the context of there's really very little to connect this event to occurring in this county.
All right, thank you, Mr. Rowland.
Contrary, Ron, a couple of things. First and foremost, even at a best case scenario, this motion is premature because, again, the venue issue is an issue to be decided, question of fact of the jury. That would be the point in time for that motion. But we don't need, people don't even think we didn't get there for a whole bunch of reasons. Mr. Truce has repeatedly mentioned the testimony of the victim and it being stricken. And what is left out is the victim indicated that she got pregnant in the residence that she was residing with the defendant. Further, as indicated in our brief, the venue is an issue that's not an element of the crime. There's also additional evidence, not just that Mr. Pap was residing in that residence and the minor victim was under his care at the time she gave, just prior to giving birth, because she was obviously in the hospital when she gives birth. But she was under his care and in that residence and residing with him at the time she became pregnant and well before she became pregnant. Now, it wasn't brought up at the preliminary examination, but, and I was going to attach this as to our brief, but I will just advise the court of it. Mr. Pap, as a registered sex offender, has to file a statement under oath in regards to where he's residing and how long he's residing there. And I'll be happy to provide this document to the court, but I'll just indicate to the court, it indicates that his residence was the one in Vanderbilt, in Otsego, on 3926 North Old 27 Gaylord, Michigan, and he had been residing there since at least April of 2023. In any case, it's not, as the court indicated, moving the time back to show that that's how she came or the time she became pregnant. It's also the fact that they were residing there, that in fact, that they were residing there all together, that Mr. Pap was in control of the minor at the time she became pregnant. And quite frankly, even if, argue is speaking, that, and as I pointed out in my brief, even if you could argue that, well, maybe they actually had sex in some other counties at some time too, it's unlikely that the victim got pregnant after only one single episode. But she got pregnant after residing with the defendant in the residence in Otsego County. And there's more than substantial evidence, more than a preponderance of the evidence that that's where pregnancy occurred. I think it's a reasonable trial of fact as well, since that's really where this motion should be brought. So it's premature at this time, would be able to find beyond a reasonable doubt that in fact, that's where she became pregnant. In addition, as the court's aware, and as is pointed out to Mr. Truce, there's a reason for that jury instruction being written the way it is with minor victims. The prosecution does not have to prove exactly the date and time she became pregnant, because again, as I've already indicated, it's unlikely that this occurred from only a single episode, which is why the offense code in this particular case and the information says on or about March of 2023. For all of those reasons, Your Honor, we feel the motion to quash the bind over should be denied. Thank you.
Mr. Truce, any response?
So, I mean, a few things. I mean, much of the prosecutor's argument here makes an assumption that I think we all know is not accurate. And the assumption seems to be that sex only happens in the home. I mean, it's just not accurate. I mean, if it was, I think the hotel industry would probably just collapse on itself. I mean, it's not accurate. I mean, we know that it could happen in any number of different places. In addition to that, I agree with him insofar as the jury instruction, but I think he's misplacing where that is. And I mean, part of it is the ultimate underlying issue with this case, but I mean, it comes to a head with this venue issue here. He's right. He doesn't have to prove an exact time and date. He does have to prove an incident occurred. In this case, because of the conception, I think he probably has proofs to prove an incident occurred. Probably. Fundamentally, though, I mean, the issue is the alleged victim has not testified that anything occurred. And again, I mean, understanding that her testimony was stricken, I mean, her statements have never been that anything occurred. Now, I recognize the prosecutor thinks that what she's saying is dishonest, and he's entitled to his opinion, and whatever happens at a trial will happen. But fundamentally, whether she's going to testify that something happened or it didn't, the burden of proving the event is on him. And I mean, if he's going to say, well, probably didn't happen from one event, he's got to be able to prove that more than one event happened. I mean, we all know it could happen from one event. Certainly could. Again, do I tend to agree? It may not be probable. But I mean, the fundamental issue that he's going to have to grapple with is what is his testimony from his victim going to be? I mean, if he wants to argue that there was a series of events, he needs something to support that. Or I mean, I guess he can argue without that, but I mean, it's a problem for him. If he wants to argue that it happened here because that's where he lived, I mean, again, he needs something to support it. And if his victim is not saying that, or potentially, if his victim comes in and says, yeah, you know, this happened one time in Sheboygan County, it's a problem.
All right, yeah, that may very well happen. I don't know what would happen at trial, but I've got to look at this in the context of the motion that's before the court, which is a motion to quash based on the bind over and the evidence that was presented at the preliminary exam for the district court to conclude that there was sufficient evidence that this crime occurred within Otsego County to bind it over to my court. And so the court's reviewing this as a motion to quash, bind over, which is how it's styled. And I think regardless of how it's titled or styled, that is the basis of it. So I'm looking at district court's decision, and was there sufficient evidence for the district court to conclude that under a probable cause standard to bind it over? When the court is reviewing those kind of decisions by the district court, the court reviews for an abuse of discretion. So we have two things kind of at play here. Number one, we have a low standard of only probable cause, and then we have my standard of review of that decision, which is abuse of discretion. It's not a de novo review, so it's not what I think or my view of the evidence is. Was the district court's decision to bind over within the range of reasonable and principled outcomes, recognizing that a different court may come up with a different decision. So what that means for the purposes of this motion is this court would find a glaring error by the district court in order to quash the bind over in this case. So was the district court's decision within the range of reasonable and principled outcomes such that it was not an abuse of discretion? So we don't have any direct evidence that I could find that this crime occurred within Otsego County, but there certainly is circumstantial evidence, and as counsel is aware, and as part of the jury instructions, circumstantial evidence by itself or a combination of it and direct evidence can be used to prove the elements of a crime. And so the court could use circumstantial evidence to find probable cause that this occurred in Otsego County. So what circumstantial evidence do we have? We have some evidence that the victim, alleged victim, became pregnant and had a child. There's some evidence that the defendant is the father of that child. Based on when that child was born, there's evidence that that conception could have occurred at a time when both the defendant and the victim were present in Otsego County. And so does that evidence meet the standard of probable cause? And that is, would a reasonably prudent person be able to conclude from that evidence that this crime occurred within Otsego County? And I think it's not an abuse of discretion for the district court to have found that a reasonably prudent person could conclude from that circumstantial evidence that this crime occurred within Otsego County. So because I can't find that there's an abuse of discretion in that determination by the district court based on that evidence, the court will deny quash. Certainly, there's a different standard at trial. This may be the subject of a directed verdict, depending on what the prosecutor is able to show evidence at trial. But again, under probable standard and abuse of discretion standard, this court must deny the motion. So Mr. Church, if you would prepare an order that reflects that ruling, and the court will sign that. We do have this set for a scheduling conference. I'm assuming that we want to get this on the trial calendar. Mr. Church.
Yes, I would like to go to the trial.
Okay, Mr. Rolla, how many days of trial do you think this will take?
I'm going to indicate, in light of the number of witnesses, probably 3 or 4 days, Judge.
Okay, Mr. Church.
And I say that based upon a previous trial where we're going to have the flip scenario, because under 768-27B, evidence of the defendant's other prior matter might be able to come in. I don't know. We'll see on that.
Okay.
I would assume probably about a half day for defense proofs.
Okay, so if we set it for 4 days, do you think that would be enough?
I think that would probably be sufficient.
Okay.
And keeping in mind, obviously, the prosecutor seems to have indicated that he may be filing a notice of other acts notice.
Okay.
I don't want to presume at this point what that's gonna look like.
Sure. Mr. Rolla, how far out do you want the court to set this trial?
Well, Judge, I think it's gonna actually be a scheduling issue for the court, it's gonna be from my office now. So I will leave that to the court's availability for a 4-day date time period.
So whenever we can get a date, you can be ready.
Please no less than 60 days, but
Okay.
but other than that, yes, Judge, I think that's appropriate. Thank you.
Mr. Truish.
I think 60 days would be fine with final status conference to proceed it. I would indicate there is some DNA issues that we're looking into. I don't know if it's going to materialize or into anything or not, but I mean, I do want to make sure we have time to explore that issue fully. I would request that Mr. Pap be transported in person for the final status conference if we could.
Okay.
I am able to schedule meetings with him. They're semi-private at best, and it does affect our ability to communicate.
Yeah, so if you can just communicate with the prosecutor and make sure it's an in-person writ, I have no problem.
I've already put a note to that effect in the file, Judge.
Okay. All right, so we'll set this for a 4-day jury trial. I will set it for a final status conference on the motion day prior to the trial date. That will be the plea cutoff. To the extent that either side has motions, they would need to be filed and set for hearing no later than the date of that final status conference. Mr. Rolla, anything else that I can address for your side? Mr. Truish.
Nothing further.
Okay. All right, Mr. Pap, that's all for this case today, and we're going to disconnect at this time.
All right, thank you.
Our next hearing's set for 10 o'clock. We'll take a short break. People versus Daniel Renlette, file number 236505. Renlette present. Yeah, council, put your appearances on.
Thank you. For the record, we're going to have the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Renlette.
True. And we had contact with Mr. Renlette. Where are we at with this case?
So I did have contact with him about a week ago. His expression to me was basically, he doesn't have a car, he doesn't have a license, he doesn't have money, he doesn't have a way to be here. I expressed to him that it's an in-person hearing and he has to be here. That was about the extent of the conversation. Subsequent to that, Mr. Bernickel reached out to me and had suggested the basis for the violations, like a driving on a suspended license in Traverse, I think, in another county. And had suggested that he would like to see how that ultimately resolves before resolving it here. I told him I kind of thought that probably was going to become a moot point.
Okay. Mr. Rolla.
Well, this is supposed to be an in-person hearing, and apparently Mr. Renlette is not going to grace us with his appearance. I don't know how the court can go ahead with the hearing, although we can have the police report, I suppose, from the driving a license suspended, but it would be my suggestion perhaps, as I think Mr. Bernickel was inferring, is let's get the conviction on the other matter. Then it's kind of a moot point because obviously you just admit the judgment of sentence. There's really no point in contesting it at that, if the court should choose to go that way.
Okay, all right. So for purposes of the hearing itself, the court will adjourn the hearing. Mr. DeLeo, if you can just communicate to Mr. Bernickel to ask the court to put it on for hearing once that underlying matter is determined one way or the other. So I'll set it for hearing in 90 days. Again, if it happens earlier than that, Mr. DeLeo, just ask Mr. Bernickel to get it on the court's docket, and we can have the hearing sooner than that. So the only basis for the violation is this driving on a suspended license.
That's my understanding, Judge, on April 3rd this year.
And this is the case, Mr. Trush, where we had that motion because the probation was extended in the first place because of the unpaid fines and costs.
Correct, Judge.
Correct. And I haven't received any information to suggest otherwise. I mean, I think outside of paying the fines and costs, he did what he's supposed to.
Yeah. Okay.
But in candor, I think outside of his bond being applied to the fines, I don't believe he made any payments.
So I'm not going to issue a bench warrant at this time. I think, quite frankly, given the status of this case, given that we probably wouldn't be proceeding today anyway, I certainly take a dim view of Mr. Renlette's unilateral decision not to appear. And if he fails to appear at the next hearing, I likely will issue a bench warrant. But at this point, I don't think it's a good use of county resources to issue a bench warrant, have him arrested, only to release him and have him show up again for the next hearing. So at this point, the court is not going to issue a bench warrant. But Mr. Trush, if you can communicate to Mr. Renlette that at that next hearing, if he doesn't appear, then we will issue a bench warrant. He'll have to appear before the court once he's arrested.
I will, Your Honor.
Okay. Are you ready for Mr. Musel's case?
I am, Your Honor, but I think that there is a victim, and I don't know if she has an intention to make a statement.
She plans on being present to make a statement.
She does. Okay. All right. So we'll wait until she's here or until 10:30. If she gets here a little early, if you let us know.
Sure.
That's our next case. Get started early.
In any event, I have a couple letters, one gets to your office.
I got one just this morning.
So that's this one.
What's that? I have that one. I don't need that.
Is that the one that you submitted this morning?
Yes.
Okay, I had a chance to read that.
I do have one other one.
Okay.
Oh, I got this one as well too, right, I think. That's all right. I think I've already read this one.
You can-
Oh,
I have to get my copy.
right, that's fine.
Okay, I'll take that copy. I'll take a short break and all right, we'll go on the record in People versus Dustin. Musel, file number 256829. The record should reflect Mr. Musel present here in the courtroom today. Mr. Musel, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
I had a phone conversation with Mr. Justin
Bernico.
and yeah, we went over it.
Did you go through it with Mr. Trush as well?
He had told me we went through it via phone.
Okay, all right. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rowland, oh, and just so the record's clear, I did receive 2 letters on behalf of Mr. Musel. I did have a chance to review those prior to the hearing here today. Mr. Rowland, do the people have any additions, deletions, or corrections?
No, you're-
Do the people have any challenges to the scoring?
we do not.
And you have a victim that wishes to address the
We
court?
do, as to the portion of the domestic violence.
Sure. Ma'am, if you come forward right up to the podium here, please. And can you tell me your name?
My name is Tara James.
Okay. Ms. Jans, what is it that you would like to say here?
I would like to say that I didn't want to press charges for the domestic violence. That I wanted Dustin to realize that he has a drinking problem and some other mental health issues that needed to be addressed, and counseling and a program for rehabilitation. The incident was unfortunate. We both were drinking that night. I believe it would never have happened had he not been drinking. And he's missed and loved. And this affects all of his family and his loved ones. That I just want him to get the help that he needs so that he can stay sober and be productive in society, because when he is sober, he's one of the best people that I know. And he helps his community, he volunteers, and he helps his friends and family whenever they're in need, and he's got a really big heart. He just has a serious disease.
Okay,
Thank you.
thank you. Mr. Trush, anyone else that would like to address the court? Or I'm sorry, Mr. Rowland.
No, you're right, thank you.
Mr. Rowland, anything on behalf of the people for allocution today?
Yeah, Judge, thank you. I'm not sure in this particular case that the credit in this matter, I believe, is accurate. Pointed out to be. probation is going, it's like 236. But it may be that that's not correct for initial arrest. I guess I would leave the patient home more forward comment on that, and I'll let them do that in a moment, Judge. Let's go once I have that taken care of.
Yeah, let's do that.
Well, I think the credit was calculated, while he's been in treatment. I don't think the statute allows for sentence credit. When a defendant's released from jail and goes to treatment, even if bond hasn't been posted.
All right. So Mr. Trush, do you have a position on that?
So, this was an issue that came up probably a month or so ago in a different case. The circumstances such as bond was amended for him to allow to be released from the jail into a treatment program. The bond was never posted. I think under the statute that he should be entitled to credit for that, because in the event that he left the treatment facility, he has to return to the jail. I mean, it's a condition. He's never been able to post the bond, so I think he would be entitled to credit for that.
All right, I'm going to hold off on that decision, Mr. DeLeo or Mr. Trush. Do we have a date that he was released from the jail for treatment?
March 18th is when he left the jail.
March 18th.
So actually, Judge, he wouldn't have been incarcerated at that time after March 18th.
Right. Okay. Okay. Mr. Rolla, your allocution.
Thank you, Judge. And I've just been advised with the court's permission, we have, I believe, father wants to speak to the court if the court will allow it. He's not technically a victim, but the court does have the authority to grant that. I think it would be a short statement, and I'm making that request at his bequest.
Mr. Trush.
I don't have an objection to it. I just want to make sure we're clear. Is this Ms. Jan's father?
Yes.
Yes.
Okay. I just want to make sure who it is.
Oh, I'm sorry. I wasn't clear on that. My apologies.
As long as nobody has an objection, I don't have an objection.
Thank you, brother.
Thank you, Your Honor. I've known Dustin for about 5 years. And over the time, I would say it's been pretty obvious to me that he has an alcohol problem and needs treatment. But I will say that in the 5 years I've known him, the only times he's ever had problems is when he's been drinking. I mean, problems with the law or problems basically anywhere. Whenever he's around me, he's more helpful than anybody I've ever known. One example, I was buying some goods at Home Depot and I glanced out and there's Dustin helping an older couple load their vehicle. He doesn't work there. They could have had somebody else, but he saw him and he went and helped. That's Dustin. When he's drinking, he has problems, but he's been in this program now for about, I think it's about 9 months and has about 9 more months to go. And in my research as a criminal justice, my degree is in criminal justice. My research on alcoholism in prisons leaves me really doubting that Justin would be able to go to prison, come out of prison, and stay sober. And I think the rest of his life, he would end up bouncing back into prison. And I just see that as a heck of an expense for the state to take on. When if he stays sober, gets into it, stays in his treatment program, stays sober, goes to a halfway house, has as long a probation as possible to prove that he's going to stay sober, I think he would be a very, very productive member of our society and a heck of a lot cheaper for us that way than to have to send him to prison. That's what I have to say. Thank you, Your Honor. Thank you.
All right, Mr. Rolla, your allocation.
Thank you, Judge. And I understand actually what the court's just heard in this particular matter, and I don't disagree that obviously when it's individual and alcohol makes it a very combustible situation. The And it may very well be that if he were able to maintain sole sobriety, there would not be a concern of the people. But there also is the other side of the situation. We're now dealing with 10th felony scenario. And because of that, the guidelines as a legislature, and I understand they're not mandatory now, but they are, it's discretionary with the court. The guidelines are 19 to 47, up to 7.5 years, which would normally be an MDOC sentence. I don't have to tell the court something, you know, I just say that for the benefit of the record, Your Honor, not in any deference to the court, just so we're real clear on that. The other situation we have is because when Mr. Musel drinks, he becomes assaultive, as is demonstrated in this particular case, both with the domestic violence, both with the resisting obstructing an officer. And I understand now he's been in the Teen Talent Challenge program, and my office received a copy of that letter dated September 3rd this morning. The questions the people have in regard are the same problems that I pointed out to the court in regards to bond, and as are effectively highlighted by the last paragraph. It says, and I'm just going to read it verbatim, while he is here, Mr. Musel will not be available for outside employment. He will have no earned income. He will not be permitted to leave the campus except for approved purpose and the company of an overseer for the program. He will have 24-hour supervision in our care. We are partnered with a meth lab to be able to meet these conditions. If Mr. Musel leaves the program, appropriate personnel will be notified. However, there lies the problem. All they do is notify personnel. It doesn't stop Mr. Musel from leaving where he's at. And unfortunately, when he gets the opportunity, he consumes alcohol and he places a danger to the public. That's the only factor that, with all due deference to both the people who provided information to the court, and I don't doubt their sincerity for 1 minute. That's the problem that I think the court also has to address, and I'd ask the court to take that into consideration in regards to sentencing. Thank you.
All right, thank you. Mr. Trish, if you and your client.
Yeah, sure.
Your allocution, Mr. Trish.
Thank you, Your Honor. This is probably one of the more difficult cases that I have on my docket. I would echo a lot of the same sentiments that we heard from Ms. Jans and from her father. I've known Dustin for quite a few years now, and when he is sober, he is a great person. He's a great guy. When he drinks, not so much. When I met with him in the jail after he got arrested on this, you know, I sat and I talked to him, and, you know, it was kind of, how did we get here? You know, what happened? Why are we back here? And he told me, you know, he had been doing great. He had been doing really good with his sobriety, so good, in fact, that, you know, they had thought that it would be okay to have some wine with dinner. And that led him down a path of 1 drink leads to 2, leads to 3, leads to him back in this situation. Dustin has consistently expressed he recognizes that he has a problem, and he wants to get help for it. And he has good periods of success. The program that he's in now is different than a lot of the things that are out there and available to him. And it's different because it is a long-term program. It's a program that, you know, again, spans almost 2 years. They're very, very similar to the sobriety court program, which frankly, he had an opportunity to do a sobriety court program a couple of years ago. The sobriety aspect of it, I think, actually was going very well for him. Unfortunately, some of the mental health things that were going on were not getting addressed. And, you know, again, sobriety was going well, mental health stuff, not so much. This program, I think, is a great, great opportunity for Mr. Musel. He's doing excellent in it. The letter is a glowing letter. If the court were to allow him to continue, he would be scheduled to finish in April of 2026. So he has still, you know, 6-7 more months that he could complete in the program. After he completes that, he has the ability to essentially stay on as staff, so essentially to help other people who are struggling with this, which I think would be something incredible for him to do, a great opportunity for him. The easy answer here for the court would be to send him to prison. I don't know that that makes anybody better. Doesn't make Dustin better. I don't think it's going to put Miss Jans in a better position. It's not going to put his family in a better position. I don't think it puts society in a better position to do that. Allowing him to complete this program, I think, does put him in a better position. It puts Miss Jans in a better position. It puts his family in a better position. And I think it puts society as a whole in a better position. I understand the prosecutor's argument that he could walk out of there at any time. And I mean, he's not wrong. I would suggest to the court, if Mr. Musel was going to do that, he's had 9 months that he's been in the program, 6 months. Every day he could have woke up and done that. He didn't. He's continued to do it. Even more so, all right, if he wanted to get out of Dodge, he had the recommendation. He talked to Mr. Burnickel. He knew what it was. He talked to me and he knew what it was. He didn't leave the program. He stayed the course. He showed up here today, again, knowing what that is. Sure, it's not a guarantee that he's going to complete it. It's not a guarantee that in the future he doesn't. But I do think it speaks to him. He's a lifelong resident of the community. And his brother works in the jail. I mean, I don't see him as a flight risk. If anything, I mean, he's the opposite end of that. I mean, all his connections are to this community. Again, I think the easy answer here for the court would be to follow the rec and send him to prison. I'm going to challenge the court here to take a leap of faith here and give him an opportunity to successfully complete this, to change his life, and again, to give back to his family the Dustin that they know and love. Thank you.
All right, thank you. Mr. Musel, anything you wanted to say?
Yes, I do, Your Honor. First, I'd like to thank my family for being here and for support. And Tara and Terry for being here and speaking kind words for me. Sorry, I'm gonna be a little emotional. I know I have done wrong in the past, and my drinking has caused most of that. But I have begun to change, and I am changing, because now I have God in my heart. I had a lot of anger built up, mostly because I couldn't forgive myself. But I'm starting to. I have this Lord as my Savior. And I haven't had that before. I haven't reached out to faith like I have been. And I just want to do everything right and continue this program. My counselor should have been online today on Zoom. He has a peer recovery program. I'd like to get into that. I'd like to continue from this ministry into the Bible college. I really want to set out to help others that suffer from addiction and alcoholism and mental illnesses. And I really want to reach out and tell them my story. It's a tragedy, but it don't have to be wasted. I can help others. And I just don't want to go down the path of darkness. God has shown me the way, and I know I have a purpose. I am down the righteous path, and I want to keep going that way. At least to make my family proud of me. Lord knows I've disappointed them so many times. And it's time to stop. Be faithful and believe that I know I can do better in life. I just want to thank you for the time you give me to talk. And I don't ask for your mercy. I just ask for grace. Keep going. I'm going to. I have seen changes in myself that I think I'd never see. I let go of anger that binded me. And I'm sorry for all this that has happened. But I believe in these events led me to where I am at today. I have never had the love, the support that I've never had this from anywhere that I have from this ministry. I just want to thank the pastors and brothers that are praying for me right now. That's all I have here.
Okay, I did read through the report, so I'm familiar with the circumstances that bring you before the court here today. There's also a lot of information in there about you and your background, your circumstances, your prior offenses. So I take all of that into consideration along with what the lawyers had to say, certainly what you've had to say, what Ms. Jansen, her father had to say. I try to look at all of that, the letters that were submitted. And I agree with Mr. Trush, this is a really difficult case for me as a sentencing judge, because there is more than enough here for me to justify and for the court to be perfectly reasonable in imposing a prison sentence, given your past history and your past failures, frankly, at attempts at rehabilitation. You know, you've been on probation many times. The sobriety court was something that I'm sure at the time everyone was hopeful would make a difference. And all of those are unsuccessful. And so there's a clear pattern here of attempts at rehabilitation and failures. And where that becomes a problem for me is, you know, continuing to give somebody a chance when they continue to fail and continuing to invest resources in that. And I had an individual an hour ago in front of me who had been on probation about the same number of times that you had. And I said the exact same thing to him. I think, though, your case is different than that one that I handled earlier this morning, based on the things that you have done over at least the past 6 months to try and correct that. And the letter that I read from that facility, I think had a lot of impact on me, because that's somebody who's completely independent. They don't have any reason to sugarcoat anything for me, or, you know, to advocate on your behalf outside of the fact that they actually think you are doing well with that program. And that other individual I had this morning didn't have anything like that and hadn't sought out any kind of program like that for help. So to me, that's a distinction that indicates to me that there is some prospect for rehabilitation here at this point, despite your past record and the past failures. And really, to me, you know, your participation in that program over the past 6 months and the fact that you're doing well in it is the difference maker. And to be completely honest with you, really the only reason why I'm not going to send you to prison today. But I want you to be very clear that this is really the last opportunity, and I'm going to give you another chance here with probation and with jail time held in abeyance. But again, the only reason is because you're engaged in a program that I think could really help and get you past this. But to the extent that you're not, you know, if you're back here on a probation violation, there won't be any hesitation on my part in any way. And at that point, the letters and everything else aren't going to make any difference, because at that point, it'll be clear to me, all right, here we are. And then prison will be the option at that point. So this is requiring me to do something that I don't normally do, which is a downward departure. Just the bottom of the guidelines on the one charge is 19 months in prison. The other one is 7 months local. But again, I think the basis for that downward departure here is your participation in that program. The letter that I received from them indicating that you are doing well in that. So I think that justifies the court's decision to give you this opportunity to continue on that path. And hopefully stay sober, because some people can have a glass of wine with dinner and it's not a big deal. Some people just cannot have any, not even one drop, and you're just one of those people. And it's unfortunate that most, if not all, of the people that I see are good people when they're sober. They're not out hurting people when they're not using drugs or not sober. It's when they're under the influence of something that they do things that they wouldn't ordinarily do. So I can accept that you're a good person when you are sober, but you need to stay that way. And so I'm hopeful that that's how this will go. I'm hopeful that you continue with this program through April of 26 and successfully complete it. I'm hopeful that you'll stay with that program if it's something that's making that much of a difference in your life, then I think you need to stay with that. And I think I've clearly outlined for you what the opposite side of that coin is. So the court is going to place you on probation. Well, first of all, I want to address the jail credit issue. I looked at the statute here while we've been going forward with the proceeding, and the statute specifically uses the language served time in jail. The court shall specifically grant credit against a sentence for such time served in jail prior to sentencing. So to me, the statutory language isn't that just that the person couldn't post or furnish bond, it's time served in jail. So I don't think that pursuant to statute that Mr. Musel's entitled to jail credit for time that he was not actually in jail. So my calculation, and correct me if I'm wrong, I don't know if you did that, Mr. DeLeo, but it's 66 days.
I had 67.
67, okay. So 67 days credit. I just want to address that issue. The court is going to place you on probation. Oh, the other thing I want to say, why I think that it's appropriate to depart downward from prison time in this case is, unlike in a lot of cases, this isn't a situation where you're just going to be released and it's just probation that's monitoring you. You're going to be in this program for a significant period of time going forward, which provides, in my view, an added layer from a public safety standpoint of supervision, of monitoring of what you're doing, monitoring your sobriety and making sure that you're not consuming alcohol. So this isn't a situation where you're just going to be out in the community and reporting once a month, maybe testing here and there. There's some serious oversight, which I also think addresses the court's concerns regarding public safety. I just wanted to make a record of that because I forgot to mention that. So as to file number 256829, count 2, resisting or obstructing, the court is going to sentence you to 12 months in the Otsego County Jail with credit for 67 days served, remainder to be held in abeyance, to be imposed in the discretion of the court. The court is going to place you on probation for a period of 24 months. The court is going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. That's to count 4. Also 12 months in the Otsego County Jail with credit for 67 days served, that time to be held in abeyance. to be served at the discretion of the court, and a $68 state cost. The court is going to impose all standard terms and conditions of probation, including that you not use or possess any alcohol, not use any or possess any controlled substances unless they're prescribed to you. The court is going to include as a condition of your probation your continued participation and successful completion in that program that you're currently involved in. So if you leave that program for whatever reason, prior to successful completion of that, that will be a probation violation. Other than that, all standard terms and conditions of probation, those two sentences to be served concurrently to each other. You do have the right to appeal these sentences, Mr. Trush, if you can provide an acknowledgement of the appellate rights for Mr. Musel.
This is on that we need clarification if it's a third offense notice. That's okay.
Okay, and Mr. Rolla, I just need you to confirm the plea offer in this case. There was a discrepancy between.
Yes, Judge, and again, I think what the plea was, as Ms. Brooker indicated, was, and the discrepancy was as with the domestic violence charge. It should have been a domestic violence second, I believe, as opposed to with a as a habitual second. And I think that's where the error occurred, which, by the way, then is reflected in the PSI. It indicates domestic violence. It said third, habitual felony second degree, which would have made that actually a 7-year penalty. And I think there was confusion as to whether that was pleading as a misdemeanor domestic violence second offense, as opposed to domestic violence third offense habitual second. And this is why the PAC code that was entered then was the 75814.
So I think on the amended information, the PAC code is 750813, I think. Is that the correct?
PAC code 750.812.
And then with the notice, it's 813.
Yes.
Okay. Okay.
Is
That's
that
right.
clear enough, Judge?
I think so.
Yes. Yes.
Very good.
Thank you.
Mr. DeLeo, is Mr. Brunical, would he be the supervising agent then?
He will be, Your Honor.
Okay, will he get in touch with Mr. Musel at his
Yep.
treatment facility? Okay.
Judge, what was on the record too, is the no contact provision continuing as a condition of probation or not?
Is that something that you're asking the court to impose?
Again,
Based on Ms. Jan's,
I've been advised by the victim as well as her father that they would like to have that listed. And as our moms explained earlier, that's up to the court to do, but I'm bringing it to the court's attention that that would be decided. I just do that on the record now, so the court has that.
right, I won't impose that as a condition of probation.
Very good, thank you, Judge.
Have we got the appellate rights?
Yes, Your Honor, I'm tendering those to the court now.
Mr. Musel, good luck to you going forward. I hope I don't see you back here. I hope in 2 years I'm signing a successful discharge from your probation.
Thank you so much, Your Honor.
Mr. Trush, we have Mr. Thompson connected. He had prior approval of the court to appear by Zoom. You're okay, good. Here's your name, Jason Thompson.
Yes, it is.
We'll go on the record now in People versus Thompson. This is file number 256870. The record should reflect Mr. Thompson's appearing today by video by prior approval of the court. Your truth. Tell me the status of this file here today.
Your Honor, we would ask the court to docket the matter for a trial. I would suggest to the court, I think no sooner than 60 days, but outside of that, whenever the first availability is. And then I'd ask for a final status conference. If we are able to get an agreement done, obviously, we will continue to talk in that time period.
Mr. Rolla, how many days of trial do you think we would need?
This particular case, by the number of witnesses, probably one.
One day, Mr. Trush.
I would tend to agree. I think I'm only seeing the prosecutor's got 4 listed witnesses, plus presumably a lab person, if that's not stipulated too. So I would tend to think a day would be sufficient.
Okay, so the court will set this for a 1-day jury trial. I think it'll end up being about 90 days out. So we'll set it for a 1-day jury trial at about 90 days. The court will set it for a final status conference prior to that trial date. That will be the plea cutoff and motion cutoff. Mr. Rolla, any other dates I can address for your side?
No, Judge, but I'm just going to indicate for the record, my call back to people. There was a plea offer in this case as to counts 1 and 3. I just wanted that reflected in the record. Other than that, nothing further. Thank you.
Mr. Trush, anything further?
No, thank you.
Mr. Thompson, have you been able to hear everything we've said here today?
Yes, sir.
Okay, so the court's going to send out notice of the date and time of your trial as well as that final status conference. It's important between now and then that you stay in touch with your attorney, Mr. Trush, so that you're prepared to go forward on those days, okay?
Yes.
Do you have any questions at all?
No, sir.
All right, thank you. That's all for this hearing, and you're free to disconnect at this time.
All right. Thank you.
Do you have Mr. Segwin present?
Yes.
Court calls People versus David Segwin, file number 256845. Mr. Segwin's present here in the courtroom today. Mr. Trush, how do you want to proceed on this file?
Your Honor, we are very, very close on this file. There's been an offer extended by the prosecutor that would contemplate him going into the sobriety court program with a reduction to an OWI second offense if he successfully completes that. We have the application before the sobriety court. They're set to vote on him to either accept him in or not on 9/9. So my suggestion to the court would be, I think we probably could set it for the mid-month day this month. We'd waive the timing requirements, but we should have an answer from them at that time. And I think that would be, right now, their acceptance or not is really the only barrier to us entering that agreement.
Okay, Mr. Rolla, any objection to that?
No, Judge, thank you.
All right, so we'll set this for a plea hearing at the court's mid-month motion day. So Mr. Segwin, just make sure that you stay in touch with Mr. Trush so that anything that the sobriety court would need to make their decision, then we have that, okay?
Yes, sir.
Do you have any questions at all?
There is one more thing that I would address to the court. Luke Hamlin, the probation officer for the drug court program, sent over a set of drug court bond conditions for him.
Okay.
I don't know if the prosecutor got a copy of it. It doesn't contain a signature line from me or the prosecutor, just Mr. Segwin and yourself.
Okay,
Judge, I'd indicate to the record if Mr. Truce wants to initial it next to his client's signature, we have no objection on that.
okay, and I can sign that. Okay, anything else we need to address on this file?
Not repeat language.
Anything further, Mr. Truce?
No, Your Honor, I will get a copy of the bond conditions to Mr. Hamlin, and then I guess I'll file the original with the court here.
Okay. All right, we'll take a short recess and we'll come back on the record. We'll go on record in People versus Anthony Gallagher, file number 256872.
Record, Your Honor, my contact.
Your Richard Trish, we have Mr. Gallagher.
Is Mr. Gallagher present?
I do not see him. The number that I have for him is a landline number, not a cell phone. When I call it, traditionally his father answers. I've not actually spoke to him in the last, since the last hearing. However, I did speak to his dad several times, who indicated they were aware of the hearing and they were making arrangements to get here for the hearing. So that's really all the update I can provide.
All right. So based on Mr. Gallagher's failure to appear back in August, this hearing was set for 11. It's now 11:24. Mr. Gallagher is not present. Mr. Rollo, the court would ask the people to prepare a bench warrant, and we'll proceed further with Mr. Gallagher's file once he's arrested and brought before the court.
Very good, we'll do your.
Thank you.
Is that your last case, Mr. Trush?
It is.
Mr. Gust, are you ready with Ms. Jefferson's case?
I am, Your Honor. Okay.
Court calls People versus Heather Jefferson, file number 256863.
For the record, Your Honor, my contact people.
James Gust, Ms. Jefferson. Ms. Jefferson, you can write to the podium, please. This is the date and time set for a sentencing hearing in this matter. The record should reflect Ms. Jefferson's present here in the courtroom today. Ms. Jefferson, have you had an opportunity to go through the pre-sentence report and talk to Mr. Gust about that?
Yes, Your Honor.
Mr. Gust, just so that you're aware, I did receive a letter from Ms. Jefferson herself. I received a couple other letters, one from Christina Jacobs and one from, I believe, Ms. Jefferson's son, as well as a confirmation of her completion of Skywood recovery. So I've had all those documents. I've been able to review those prior to the hearing today. Do you have any other additions, deletions, or corrections? Yes,
None.
Okay. Any challenges to the scoring of the guidelines?
None.
And Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring? Anything on behalf of the people for elocution today?
Yes, Judge, as the court will recall, it's a situation where Ms. Jefferson was in residence belonging to a co-defendant, Lawrence Warner, who's already been dealt with by the court. That he was away in substance abuse treatment when many of these things happened, but the weapons that supposedly were to be locked up were not locked up. In fact, as indicated in the PSI and the police report, the weapons were all over the residence, including in numerous bedrooms occupied by Ms. Jefferson's sons and or their girlfriends and or both. It's a situation where the defendant was on probation out of Isabella County at the time. And we ask that the guns and weapons obviously be already confiscated and condemned as was ordered by the court in the other previous case. The guidelines in this particular case are 10 to 23 up to 10 years on the possession of meth charge and 7 to 23 up to 5 years for Ms. Jefferson's third and fourth felonies. I understand, and I've also had the opportunity to read the letters that the court referred to. I would point out if there's a case where there was a potential for things going very bad to endangering the public with the way the weapons were not only handled, but apparently perhaps used on the premises. This is one of those cases, and the court needs to take that into consideration in regards to sentencing. Thank you.
Thank you. Mr. Gust, anything on behalf of your client today?
Yes, Your Honor. Ms. Jefferson is 40 years of age. She has been in custody in the Otsego County from September 2024, and she was transferred to Isabella County in December of 24. In April of 25, she was transferred to a residential treatment center where she spent 30 days. She was involved in an intensive aftercare program, beginning with, I think, for the first 30 30 days or more, she had to attend counseling three times a week for 3 hours. She currently attends counseling once a week at Up North psychologically, psychology, and twice a week, one for group and one for individual one-on-one counseling. If you look at her record, it's a record of substance abuse. Been a lawyer 50 years now, and I look at substance abuse as, you know, if there was no substance abuse, we'd probably need 10% of the lawyers, criminal lawyers. So much is fueled by substance abuse. So many crimes are fueled by alcohol and drugs. She lived the life of an addict for probably over the past 20 years at this point. As law enforcement has tried various ways to deal with the drug problem in America, obviously the penalties haven't been successful. In the 70s, they went to mandatory prison sentences, 10 years. You get life if you had a large quantity of controlled substance. None of that worked. The thing that's most significant for me in my career is that I'm always aware of what drugs cost because we hear about it in court all the time. Cocaine's cheaper now than it was 30, 40 years ago. So we can't stop drugs from coming into our country. I think the school of thought has moved to how do we deal with the addiction issue? Because that's the real problem. As long as people in America want something and have money to pay for it, we're always going to have drugs here one way or another. It can't be stopped. And look at the strides that she has made in the last year. And she's been sober for a long time, I suspect. She's done very well in treatment. As she stands here today, the person she is now, she would have been this person for the last 20 years. She would probably have no criminal record at all. We wouldn't be here. Prosecutor mentions the issue about firearms. There is a prohibition against people with felony convictions having firearms. I don't think the reason for that law was for people like Ms. Jefferson. She's never been involved in a violent crime. She was living with a boyfriend who had numerous guns. I would suspect it would be hard to find a house in Otsego County that didn't have firearms. So I don't believe that the firearms in her house are a threat to anyone. She's never used one for any criminal activity. None of the firearms were ever used for any criminal activity. They were hunting guns, basically. She has come a long way. She has support of her family who are all here today. All the members in the courtroom are related to her. And talking with her, the addiction issue has finally gotten her attention. Should have gotten her attention long ago, but it hadn't. You see very few success stories in dealing with addiction in my practice. Greatly appreciate when I do see a success story since her release from jail in April of this year. She's demonstrated she has a success story. To now, from the recommendation of the probation officer to sentence her to prison, I don't know what we can accomplish by that. It's not in the best interest of society. And we have a person who has dealt with everything she's dealt with her addiction. As a society, all we want people to do is quit using these substances, quit abusing drugs and alcohol. Done that. I don't think any further incarceration would help her or help society. To put her on a long period of probation, just see if she's sincere about her addiction problem, dealing with it, do the right thing. It's proven that at least in the last month she has dealt with it, in a proper manner. So I would just ask the court to impose a sentence that does not include incarceration.
All right, thank you. Ms. Jefferson, anything that you wanted to say today?
So you had a chance to read my letter.
I did.
Okay, so I guess I really been sitting on that letter for like a year now, and I've added to it, critiqued it a little bit. But since you've had a chance to read it, I guess I don't need to read it in front of you. I volunteer at animal shelter 4 days a week. I go to 80 meetings. I go to my counseling twice a week. My youngest son is 16, and he is also on probation. He got into some trouble when I was incarcerated, and I've got him back on track. Now we are doing this together. We both go to animal shelter. I want to give back to the community and volunteer my time. I want to be a meaningful and productive member of society, and I want to show my son the same thing. Like I said in my letter, I want to show them that you can take something bad and turn it into something good with the right kind of help and the right kind of attitude. I want to be able to stay out here and do this with my son. We can do this together. We're both on probation. I just want a chance to be a better person. I am so glad that I did go to jail. That's what I needed. I have been sober since, and my life has been so different. I'm kind of grateful that I did go to jail. I needed it. And I feel like I did my consequences. Sorry, I just want a chance to continue my journey to recovery with my son and prove to the courts that putting me in prison is not the best interest in anybody in this case. Them guns were not mine, and I had no idea that they were around the house like that. I mean, I had told Larry to get rid of them numerous times. I just don't know how, I don't know why he didn't. I just really want a chance to prove that I'm a better person, and putting me in prison, I just don't think it's going to do anybody any good. I want to be here for my son. I know that we can do this together. I've been doing so much better, and I love my life now, and I'm going to stay on the right track no matter what. I just want a chance to.
Okay. All right, Ms. Jefferson, I did read through the pre-sentence report, so I'm familiar with all the information contained in that report. Not only about the offenses that came before the court here today, but also just your general background and circumstances. And so I take all that information into account, along with what the lawyers had to say, what you had to say, both here in person and in your letter to the court, as well as the other letters that were submitted. You know, the most significant thing that I read was the letter from the recovery center that you did rehab
Yeah.
in. I said this to an individual earlier today, you know, those people don't really have any interest in what happens going forward. So they're generally, I think, an objective view for the court to look at in terms of what you've done since this charge occurred. So I place a little bit greater weight on that, the fact that you did successfully complete a rehabilitation program. Was that an inpatient?
Yeah.
Yeah, so I do place a little bit greater weight on that. Certainly, given your past history and the guidelines in this case, which are straddle cell guidelines, which means the court has the option of either jail or prison. I think your prior history certainly would warrant a prison sentence, and the court could reasonably impose that. As I indicated to an individual earlier today, though, I think a significant factor here are your efforts at recovery, which I'm not sure has occurred in the past. Maybe you were encouraged to do that through probation or ordered to do it. But the fact that you sought out that help on your own this time indicates to me that maybe you are looking at this a little bit differently. And because the court does have the option of going with a community sanction here, given that this is a controlled substance offense, possession offense, I tend to agree about the weapons. I don't know, based on what I read in the PSI, I'm not sure what kind of level of involvement you actually had with those weapons, or whether they were just present. Certainly, you shouldn't have been in a place where those were, but I don't find that to be an aggravating factor in this case. So the court finds that it would be appropriate in this case, given all the circumstances, to impose a community sanction as opposed to prison sanction. So to that extent, I am going to part from the recommendation. I am going to place you on probation for a period of 24 months. The court is going to adopt as the conditions of probation all the standard terms and conditions, including that you not use or possess any controlled substances unless they are prescribed to you, and that you participate in and successfully complete any other treatment programs that are recommended to you by your probation agent. And again, that'll be for a period of 24 months. The court is going to order that you serve, and I'm going to hold this time in abeyance, but the court is going to order that you serve 12 months in the Otsego County Jail with credit for 2 days served. The court's going to hold that time in abeyance to be served at the discretion of the court. So if you violate your probation in any way, I can impose any or all of that jail time without even making a determination about a probation violation. In other words, if there's any indication that you're not complying with probation, then I can impose any or all of that jail time immediately, without a hearing, without anything else. Just do not pass go, you're going to go straight to jail. And that's on top of, if you do violate and you're found guilty, the guidelines are up to 23 months in prison. And so if you're not successful on probation and you're found guilty of a violation, I'm not going to have any qualms about imposing a prison sentence, because at that point, it'll be apparent to me that it's just not working. And then the only other option at that point is prison, and there won't be any argument that'll convince me that that's not appropriate then. So I hope that you continue on the path that you're on, because I don't want that negative option to happen. And I hope that we have a successful completion of probation. But if we don't, I want you to understand that there's a significant consequence to that. And this is really your last opportunity to avoid prison. You haven't had a prison sentence in the past. We will have exhausted all other options. So That is the sentence of the court. You do have the ability to seek an appeal of the sentence. Mr. Gus, if you can provide Ms. Jefferson with her appellate rights and have her acknowledge those by initialing or appropriate.
The court is ordering the weapons and ammunition confiscated.
Yes. Yes.
In conjunction with all the other co-defendants.
Right. In addition to the probation, the court is ordering a crime victim's assessment of $130, court cost of $325, a state cost of $136, and a supervision fee of $30 per month while you're on probation. That's as to both counts. Sir.
Thank you very much.
And Mr. DeLeo, is Ms. Davis can be the supervising agent?
She will, Your Honor.
Will she get in touch with Ms. Jefferson?
She will. Ms. Jefferson is currently on probation, like we're reporting to her, so she'll.
Okay, thank you. That's all for today. I believe that's all for the morning hearing. We'll be in recess until 1:30.
All rise.